Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as is the norm, we have a packed agenda of issues to discuss. I want to begin, as I normally would do, by welcoming all of our television viewers who are joining us from West Coast Berbice Region number 5. Welcome to another program of Issues in the News. To our viewers who are joining us on television from across the Berbice River, the east bank of the Berbice River, New Amsterdam, Kanji, and along the Quarantine Coast, welcome to another program of Issues in the News. To our listeners and viewers who are joining us on Freedom Radio from Robb Street, Georgetown, welcome to another program of Issues in the News. And last but not least, to our friends and followers who are joining us on Facebook Live across the length and breadth of Guyana, the Caribbean, North America, Europe, Asia, and even further afield. Welcome to another program of Issues in the News. Please press that share button on your phone, press that share button on your computer, on your laptop, on your iPad, on your tablet, or whatever device you may be using. Share this program, share this live, so that as many of your friends and followers as possible can join us in tonight's discussion. Mala Ramnath, Soma Bipat, Maureen Rosario, I saw earlier Madbal Singh, Jack Jagdev, Shelley Philander, Robert Rampasad, and so many of you. Welcome to another program of Issues in the News. Please use the comment section to raise issues that you may wish me to discuss. Use the comment section also to ask questions that you would like me to answer, or raise any issue that you want me to discuss. As I often say, I would like this program to be interactive and as engaging as possible. So we have a packed agenda as usual. I want to begin by extending solidarity to our brothers and sisters in the Eastern Caribbean area who are reeling under Hurricane Beryl that struck across those islands yesterday and maybe still continuing. It was devastating. Hundreds of homes were destroyed, a lot of people injured, and I want to use this platform to say to those people that our prayers are with them. The government of Guyana has dispatched supplies and has indicated that we will render whatever assistance we can to ensure that our Caribbean brothers and sisters survive this horrendous ordeal. I saw some images of the speed of the wind. I saw some images of the destruction that occurred. I saw some coconut trees bend like paragrass in the wind. I saw roofs flying off. I saw vehicles being physically lifted from the ground. I saw boats and ships being sunk and destroyed at the various harbors. So a lot of destruction have taken place, and I want to stand with our brothers and sisters in the islands affected and to say to them that our prayers are with them, and as a government we will do all that we can do to ensure that they recover from this phenomenon. We also had a disaster last evening where several buildings were destroyed by fire at Bushlot, West Coast Berbice. And from the reports I've received, one person is dead. That person has been identified as a Carl Passad. So my sympathies go out also to the persons who have lost Mr. Carl Passad, and importantly, my commiseration goes out to those whose homes and businesses have been affected by the fire. From the reports I have received, the response of the fire service from this fire service leaves a lot to be desired. We cannot keep making the same mistakes. Fire engines cannot keep turning up to fires without water. This is unacceptable, but I suppose the subject minister will speak more elaborately on this issue at an appropriate time. But the response of our fire service must be drastically improved. The people of our country deserve better. On the 10th and the 11th of July, the government of Guyana, in collaboration with the Academy of Law of the Caribbean Court of Justice, will be hosting a mega law conference at the Marriott Hotel in Georgetown, Guyana. Mark the date, the July the 10th and the 11th. We have a number of dignitaries who will be participating in this very important law conference. These dignitaries include Her Highness, the Commonwealth Secretary General, Patricia Scotland of King's Council, the judges from the Caribbean Court of Justice, the Chief Justice of Belize, the Chief Justice of the Court of Appeal of the Eastern Caribbean, and many High Court judges and Court of Appeal judges from across the region, including, of course, Guyana. Several attorneys general from the region would be attending. Several director of public prosecutions will be attending. And, of course, several members of the legal profession from across the region and, of course, from Guyana will be participating. This law conference is part of the IDB-funded Support for Criminal Justice project currently being executed by the Ministry of Legal Affairs. Some of the thematic issues that the conference will address will be as follows: eliminating case backlog, plea bargaining, children's court experience, the role and impact of the Public Defender's Office in a modern criminal justice system, the voice of the victim of crimes, and the use and value of victim impact statements, a case for sentencing guidelines, out with the old and in with the new, transitioning from preliminary inquiries and paper committals to sufficiency hearings, implementing a code for prosecutors, dealing with DNA evidence in court, the benefits of judge-alone trial, towards a new sentencing policy, the role of restorative justice in the criminal justice system, shifting the culture of punishment, restorative justice, pursuing a career in the practice of criminal law, delaying justice is denying justice, abuse of process in criminal justice in the criminal justice system and available remedies, the art of fact-finding, and the Needham's Point Declaration. These are some of the important themes that will be interrogated, discussed, and examined by the legal experts who will be attending this conference. So far, over 250 persons have registered to participate in this two-day conference, which will take place once again on July the 10th and the 11th. That's next week. So I wanted to share that information with you. I have received a few questions from the press. One question asked of me is, there are concerns about the Constitutional Reform Commission not having met since it was constituted. How soon are they expected to meet, and what is the order of business? So, as you may be aware, the Constitutional Reform Commission is a statutory commission appointed by His Excellency the President. My role in assisting with constituting the commission was as a result of a directive from the President. I was a delegate of the President tasked with the responsibility by His Excellency to constitute the commission, to make the seat of the commission available, to furnish and equip the seat of the commission so that it can conduct its affairs, and to ensure that the members of the commission were appointed and took their oath of office. I have discharged those functions. I am a member of the commission. The commission has a chairman, and the commission will determine when it will sit and will regulate its business. I am only a member of the commission. I can disclose that the site of the commission is ready. There were some minor adjustments that had to have been completed in the building where the commission will conduct its business, and those works have been completed. So I would expect that very early a meeting of the commission will be summoned by its chairman, and it will begin to organize its work agenda. So that is what I would say in relation to that question. Another question that came from the press is in relation to the business or the businesses that are the subject of sanctions by the US authorities. It will be recalled that late last week, a correspondence was received by the Minister of Finance informing the Minister of Finance that the Attorney General of Guyana should communicate with the Department of Justice of the US, utilizing a particular facility, which is the Mutual Assistance Act, in communicating with the US on this matter. The question is whether I have commenced that course of communication. I have not done so as yet, and I expect to do so before the end of this week. Another question relates to my exchange with the Chief Justice regarding the time limits for judgment. And the question is, in its recent ruling in the case of Gaskin against Minister of Natural Resources of Guyana and others, the Caribbean Court of Justice said that the time limits for judicial decisions must be construed as being discretionary in nature. Can the Attorney General kindly comment on the CCJ's ruling? Well, my comment on the CCJ pronouncement on that matter, on that issue, is that the CCJ has interpreted the Time Limit for Judicial Decision Act utilizing the established canons of construction of statutes. And those canons dictate that whenever a time is stipulated for an act to be done, that time frame must be construed as directory or discretionary and not mandatory. And that is all that the Chief Justice, the Caribbean Court of Justice, has done. So I am in agreement. And why such interpretation is placed on time frames in law is because laws must be interpreted sensibly, and therefore there may be a multiplicity of reasons which would justify non-compliance, or which may justify non-compliance with the particular time frame. And therefore, if one is to construe the time frame as being mandatory, then a breach of the time frame will result in the act following to be illegal, and that can lead to an undesirable state of affairs. So if you are to file a particular document within a period, and that period expires, it does not mean that you cannot file the document at all. It means that you must go to the court and seek an extension and show good reason for not complying with the time frame in the first place. Applying that principle to the time limit for Judicial Decisions Act, if a judge breaches that time frame, then but delivers the judgment outside of the time frame, then the delivery of that judgment or the judgment itself is not rendered illegal because it is in violation of the time frame. The judgment remains legal. But of course, the judge is obliged to give good reason why the time frame was not complied with. So in the past, judges may have had a good reason in that there were not sufficient number of judges on the bench. So that may be considered a good reason. But that reason no longer exists, because we now have an additional 10 judges. So I am happy that the CCJ has pronounced on the matter. The CCJ didn't say that the law must not be complied with. The CCJ did not say that the law is unlawful, in that it is violative of the Constitution. All the CCJ said that the law is discretionary. What that means is that you can breach the time frame, but you must have good reason. And that's all we are asking the judges to do. But the law is there, and it must be a guide. And only as an exception should it be violated. But whenever it is violated, it is not an illegality. So I hope that the pronouncement of the CCJ is interpreted in a sensible manner. The CCJ is not saying that the act must not be complied with. Of course the act must be complied with. But if it is not complied with, then good reasons must be shown for the non-compliance. And the non-compliance doesn't render the judgment or the decision illegal because it's in violation of the act. The only exception to that type of interpretation, as you, the viewers, would know, is in relation to elections petition cases, where the time frames once stipulated by the law cannot be violated. The courts regard time frames in elections petition, as APNU, AFC learned very bitterly. They are incapable of a discretionary interpretation. All time frames in relation to elections petition are mandatory and must be complied with. And that is why elections petition jurisdiction is regarded as sui generis, as peculiar, as special. Why? Because a government has to be in place. And if you're questioning the legality of a government, you got to do so quickly and swiftly. Because without a government, the entire country can fall into a state of chaos. And that's the rationale behind election petition rules being so strictly construed. And that brings me to a point, and we must not allow these things to remain on the public record without repudiation. Someone drew to my attention Mr. Roysdale Ford explaining that he was not responsible for petition number 88, petition number 99 to be dismissed. You would recall that petition number 99 was dismissed because it was served on Mr. Granger outside of the time prescribed for service of the petition. As I have made the point repeatedly, these time frames are fatal when they are breached. So, Mr. Granger was served some 5 days late. And the petition was dismissed because of that. I heard Mr. Roysdale Ford strenuously arguing that he was not Mr. Granger's lawyer and therefore he was not responsible for what Mr. Granger put in an affidavit, that he was the petitioner's lawyers, not Mr. Granger's lawyers. He is right. He was the petitioner's lawyer. And it is the petitioners whose duty it is to serve the respondents the petition within the time prescribed. So he violated that duty as the petitioner's lawyers. So it mattered not what Mr. Granger said in any affidavit. The issue is, or was, and the fact was, that Mr. Granger was served a petition 5 days late. And that was the point that I took. That was the objection that I took. And who is responsible for serving the petition? The petitioner's lawyers. So I don't understand how Ford can attempt to shift the blame from himself to some other person. I am a lawyer too. I filed the elections petition too. And were they filed outside of the time, I would have had to accept the responsibility. Is Mr. Ford saying that Mr. Granger should have said in his affidavit that he received the petition in time when he received it outside of the prescribed time? Because Mr. Ford seemed to be arguing that Mr. Granger in his affidavit said that he received it out of time. But what do you want Mr. Granger to say if he received it out of time? And who is to serve it within the time if it is not the petitioner's lawyers? So I just wanted to correct the public record in that regard. And let us say, so that's one. So what happened to petition number 88? Who caused that one to be lost? Is Mr. Ford who filed that too? And in that one he was arguing nonsensically that Order 60 collided with the Constitution. He lost that too. He lost that at the High Court. He lost that at the Court of Appeal. And he didn't appeal to the Caribbean Court of Justice. So is it that he wants to blame somebody for that one too? The truth of the matter is that these petitions should never have been filed. But if you choose to file them, and when they are dismissed, you must accept the responsibility. You must not be allowed to shirk the responsibility. He doesn't win many cases, but whatever cases he wins, he takes the credit for it. So when you lose, you also have to accept the liability that comes with losing. All the cases that were filed during the recount period, he filed all, and he lost all. Is there somebody else to be blamed? This is the same thing with Basil Williams when he was Attorney General. Every case he filed, or most of the cases that he filed, he lost. And he always looked around for someone to blame. Ford seems to be adopting the same approach. So I thought that I would repudiate the narrative that he's attempting to peddle. I lose cases too. But when you lose the case, you lose the case. The buck stops at you when you are the lawyer. I understand that full well. It's just that I don't lose a lot. And that's the truth. Because I don't file cases that are not deserving. So I'm trying to get your comments here. Let me see. So we had a very important development over the last weekend. Many of you may have read in the newspapers an order published by the Chancellor Acting of the Judiciary creating a new magisterial district. That is to say, the magisterial district of East Bank, Demerara. Many persons may not know that the East Bank of Demerara was not a magisterial district. It was considered part of the Georgetown magisterial district. So the court at Providence, the court at Diamond Grove, those are where the two courts are on the East Bank of Demerara, were always part of the Georgetown magisterial district historically. Well, we are building more courts. We are building a new court at Providence that will house more than one courtrooms. We have built a court at Diamond Grove. I understand there are 3 courts there now. We are building a court at Friendship on the East Bank of Demerara, and we are building a court at Soosdijk. So the need arose for the establishment of a magisterial district specifically for East Demerara. So you will have a magistrate's office at East Demerara. So charges and proceedings can be filed in that magisterial district by going to that office that would be located. I think the office is located at Diamond. Prior to that, all these charges had to be filed in Georgetown at the Georgetown Magistrates Court's office. Now they can be filed on the East Bank because you now have an East Bank magisterial district. So that's another very important announcement that I would like to make. We had over the weekend the conferences of the APNU, well, PNC, and the AFC. And you saw the drama which unfolded in both elections. So, as you know, the PNC is undemocratic by its very nature. And so is the AFC, and I will deal with them separately. But these are political parties whose members and supporters would want you to believe that they are the champions of democracy. Up to now, they walk around telling people and believing and persuading themselves and publishing in the social media that they have lost, that they have been cheated at the 2020 elections. They have not yet accepted that they attempted on multiple occasions to steal those elections through Mingo, through Lowenfield, through the recount. And all of you witnessed it. Yet, and the 100 governments across the globe witnessed it and condemned them for it. But yet, they are calling our government an installed government. And they pretend to be the champions of democracy. And then every time they have elections, internal elections, you see the hand of fraud. You hear allegations of fraud from them. From them. When they had the previous elections, Aubrey Norton himself is on public record, along with Carl Greenidge, as saying that those elections were rigged. That's when Mr. Granger was elected leader. Check back the record. They, and many of them, Greenidge, Norton, and many of them, publicly lamented that those elections were rigged. This time around, the contestants again, Roysdale Ford, Amanza Desir, repeatedly said that the elections process was compromised. They repeatedly made allegations of impropriety. They repeatedly made allegations of electoral irregularities, and that the foundation is laid for the elections to be fraudulent. In the result, they both withdrew from the contest. Why would they withdraw? Why did they withdraw? Because, however you style it, the reason for their withdrawal was that the elections were not going to be free, fair, and democratic. And you can read their many statements. They're published all over. If they can't ensure that their own elections are free, fair, and democratic, if they can't if they are accepting publicly that their own elections are undemocratic and fraudulent and irregular, then how can they present themselves as democratic? How can they ever speak about free and fair elections and about a transparent process? And this is the main opposition party. How can they even begin to muster the credibility of speaking about rigged, about fair elections in the future? How? And let us go across to the Alliance for Change. Nigel Hughes and Patterson decided by themselves that they will work out a deal, and they incorporated Trotman. And it was a fait accompli. Of course, wherever Nigel goes, Cathy Hughes goes. They are man and wife, husband and wife. So it is the nucleus of the leadership that hijacked the elections from the electorate. If the leadership decide that we want this particular leader, what message are you sending to the rank and file members? So it was in that you have incest, you have husband and wife, you have nepotism, you have friends, and they threw out Comrade Ramjatan completely. And obviously, Sherrod Duncan became a casualty. Poor Sherrod. And you know, the opportunism that I saw there. The campaign started, poor Sherrod. I mean, whether you like him or not, he is there day in, day out. He's on several social media platforms. He visits the parliament now and again. He takes a sleep on the floor whenever he gets ready. He disturbs the parliament. But he's there. He's on the ground. Nigel Hughes leapfrog a week before the elections and hijack the whole thing. Poor Sherrod, I see Sherrod saying you can't buy an entire political party for $4,500. Apparently there's a membership fee. But that is what happened. And obviously, with that kind of influence imposed, the rank and file members really didn't have a say. That's what you call undue influence. It sapped the people's independence to vote. If you have Nigel Hughes on one, Nigel, Patterson, Cathy on one side, and obviously they will have Beverly Alert and so on. They have all those people on one side. Who will vote for Sherrod Duncan? And this was hatched a week before. A week before Mr. Hughes is seen photographing himself and bottom houses and so on. So that is what you have passing for democratic elections in these political parties. And that is why they cannot come close. They cannot come close to the People's Progressive Party. Look at their Congress or Congresses and look at the PPP Congress. It's chalk to cheese. There's nothing to compare. Nothing to compare. So, Mr. Hughes is still enjoying his honeymoon, so we will leave him a little, and then when he gets his feet wet, the political discourse will intensify in respect of him. Monday, the 8th of July, we will have a sitting of the National Assembly, and some very important bills will be debated and hopefully passed. These include the paper committal bill, and this is a very important bill for our criminal justice system. It abolishes oral preliminary inquiries completely from our system. Oral preliminary inquiries have been with our system for over 100 years. Whatever may have been the intent of it when it was first introduced, it has lost its efficacy. An average preliminary inquiry now is like a mini trial. That is what it has been reduced to. It takes about an average of over 3 years to complete. Most of the time it is in relation to murder, and the man or woman is remanded. The prisoner is remanded. So you have about an average of 3 years of pre-trial incarceration, because the process is extremely slow. Witness, one after the other, has to go into the witness box and give oral testimony, and then cross-examined, and then you have to hold a voir dire if there is a confession statement, and then the accused may wish to lead evidence, and these things take a long time. The toll on the state is tremendous, because the state has to maintain the accused person in the prisons and is responsible for their expenditure in relation to conveyance to and from court. Some of these courts are way in the interior, and the prison centers are in Georgetown. And then it takes a toll on the accused persons themselves, because many a times it interferes with their right to a fair trial within reasonable time. The system has been abolished throughout the Caribbean. Guyana is perhaps the last jurisdiction to do so. Here, now, after this act is passed, this bill is passed into law, the statements of the prosecution and the statements of the defense must be submitted to the magistrate within 45 days of each other. There is a facility to grant an extension of time, and once that is done, the magistrate reads it, and here's the lawyer for the accused person and makes a decision. So the entire process can be concluded in a matter of a few months. rather than 3 and more years. We have in our system preliminary inquiries that have lasted for 10 years. I'll speak about it in the Parliament. There is an Amerindian gentleman who is currently suing the state for millions of dollars because his preliminary inquiry took nearly a decade to be concluded. Imagine a man is on trial for 10 years. He's on remand awaiting trial for 10 years while he awaits the conclusion of the preliminary inquiry. This is simply unacceptable. And the bill also provides that magistrates, when they adjourn the paper committal proceedings, they must not do so for more than, I believe, 29 days. So it's not there is time frame stipulated in the process as you go. So this paper committal system should bring great speed to the criminal justice system in relation to capital offenses in particular. Paper committal has been in use in Guyana since 2010 by virtue of the Sexual Offences Act. It has been in use in the Caribbean for close to 20 years now. There were legal challenges and they have all been concluded because, you know, it doesn't allow for cross-examination, etc. Persons challenge it on the ground that is affected their right to a fair trial. Well, our Court of Appeal has ruled and the Privy Council has ruled in Caribbean territories that that is not so. So that bill will be debated. The Fugitive Offenders Amendment Bill will also be debated. That, as I have said before, is a very important piece of legislation. It simplifies the extradition process. It makes the extradition process fluent, and it removes a lot of technical evidential burden from the proceedings. It does not in any way impact negatively or prejudicially against the person who is the subject of the extradition proceedings. It's only procedures that are being changed, not the substantive law. The substantive law of extradition remains unchanged and will remain unchanged. It is simply to clarify and to make less technical certain processes. If you are interested, please follow the debates and you will understand the intricacies of the amendments. The other important piece of an amendment that is going to be debated is certain amendments to the Road Traffic Offences Act. Now, you would agree with me that we have an unacceptably high level of road fatalities in this country. The road carnage in this country per capita is perhaps one of the highest in the Caribbean, if not the entire Commonwealth. Every year, hundreds of our citizens are dying on the roadways of this country. And in circumstances that can be avoided. Two main factors account statistically for most of the road accidents in this country, particularly the fatal accidents. One is drunken driving, and secondly, speeding. In relation to drunken driving, and they are related, invariably the drunken driver speeds, but you have sober drivers who also speed. We have already passed a series of statutory interventions designed to address drunken driving, including regulating the way alcohol is sold to drivers and potential drivers and likely drivers. We have increased the penalties for drunken driving. We have created a new offense called motor manslaughter in respect of persons who have caused death while driving drunk. We have imposed a regime of suspension and disqualifications in respect of driver's license for drunken drivers and repeated offenders. Now we are taking another suite of statutory interventions specifically to address speeding and failure to wear seat belts. These provisions allow for the establishment of CCTV cameras across the roadways, and using the available technology in these camera systems, persons will be charged based upon the speed recorded by these cameras and photographs taken by these cameras. And a ticket, a traffic ticket, will be generated and electronically transmitted to the registered owner of these vehicles, and the owners will have to go to the magistrate courts of this country to pay those tickets or to contest the charge in the magistrate's court. The same images will also be used to detect when you are not wearing seat belts, and these cameras and the technology in the cameras will generate also the images, and you will be notified electronically of the charge in respect of not wearing seat belts. All these images, these cameras are going to be monitored by members of the Guyana Police Force who are trained. We will have a database. The database of the GRA will be integrated into the system, so we will know each registered owner of vehicles. Each registered owner will be required within a stipulated time to provide email addresses so that they can be communicated using those email addresses. That's where they will receive notifications. Also, messages will be sent on your mobile phones, so you will have to submit that mobile phone number as well. And there is a mechanism that will allow these tickets to be attached to your driver's license, so when you go to renew your driver's license and you have tickets outstanding, you will have some problems. This system has worked in North America and it has been implemented in several countries in the Caribbean already. We are moving in that direction. Again, I invite you to look at the debate so that you will understand the elements of this very important piece of legislation. If you are the owner, but you are not the driver of the vehicle, you will get the ticket. You will get the e-ticket, and you will have to disclose who is the driver, and the driver will also be charged upon your disclosure. So, I can't explain everything here. I'm running out of time, but this bill will be debated next Monday in the National Assembly. So, there are some very important pieces of legislation that I want you to acquaint yourselves with, and a good beginning is to listen to the debates when they will be conducted on July the 8th, that's next week Monday, in our National Assembly. I want to thank you very much for spending the last hour with me. I have gone past our time, so I want to thank you very much, and I will see you next week Tuesday. Enjoy the rest of the evening, and be safe until we meet again next week Tuesday. Thank you very much. Thank you.